Getting ready to get started, please make sure your phones are silenced. All right. The Court of Appeal in for the 6th District of the State of Florida is now in session. The Honorable Joshua A. Mize, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to this oral argument session of the 6th District Court of Appeal. My name is Judge Joshua Mize. To my left is Judge Joshua Pratt, and to my right is Judge John Stargell. We are being live streamed, so everyone please keep that in mind. If you have not silenced your cell phones, please do that now. We have two cases on the docket today. The first case is 250921, Maureen Koch and Lucille Bishop versus Sanford Health et al. This is a law day, so we'll have a question and answer session afterwards. So lawyers, if you will, please stick around for a moment. And students, if you do have any questions, you'll have a chance to ask them at the end of the lawyers or us. Appellant's counsel? We normally save 5 minutes for rebuttal. Is that okay, or would you like more or less?
Perfect, Your Honor.
All right, please proceed.
May it please the court. My name is John Martino, and I have the privilege of representing the appellants, Ms. Maureen Koch and Ms. Lucille Bishop, in this appeal today. This appeal is not about whether or not punitive damages should ultimately be awarded in this case. It is about whether the trial court followed the procedure mandated by the legislature before punitive damages may even be pled under Section 768 of the Florida statutes. Pursuant to 768.72, the court is meant to determine whether a reasonable showing for a reasonable basis of recovery for punitive damages can be found.
finding that was superfluous, that didn't have to make, but it doesn't negate the other finding. Both those things could be true. It's not like they're consistent, right? I'm not seeing any evidence that there was any type of managing agent or an officer involved in those statements. What am I missing?
Well, first, what I would say
Go ahead.
so. As I was held the plaintiffs to a higher burden, had an amendment state established that there was a reasonable showing of a reasonable basis. for
I took your point in the brief about the proffer. And some of those items seem to have been, I'm not sure they were evidence in the record. I'm not sure the trial court relied on them, but I take your point that at least some of those items wouldn't appear to be evidence in the record. We look at that, if we were to find that the trial court, utilized improper evidence, and we think you relied on it, we would do a de novo review on whether or not you met the standard. And when I look at the defendant has to have knowledge that there was a high probability that this plaintiff would be injured, specific to the plaintiff. And it seems like in the context of a flood, that would mean you had to show the defendants had actual knowledge that there was a high probability that a flood would happen while the plaintiffs lived in this apartment.
Right.
Just being in a flood zone doesn't mean there's going to be a flood at any particular time or any particular apartment's going to be flooded. Is there any evidence that they knew there was a high probability of a flood happening during this year of the lease and affecting this apartment? I mean, how could anyone ever know that?
Right. Figuring out exactly when it's going to happen, absolutely. Your Honor, that's impossible.
All right, so then how do you meet the standard that they had to know there was a high probability that it would happen? If you said nobody could ever know that.
Because the court may have read there were grant applications that the appellees filed to the government, basically asking for funds to undertake large mitigation projects.
They're trying to mitigate the problem. We're going to punish them for that going
No,
forward?
absolutely not. That's not what we're seeking to punish them for. The relevance of those applications is that within them, they said the risk of reoccurrence was extremely high and will happen at any time.
No, so I'll take your point on that, but if you kind of assume that, they had to have knowledge that there was a high probability that this plaintiff would be injured.
Right.
So that would mean that just establishing there's a high probability that a flood will occur at some point does not establish there is a high probability that a flood will occur during this lease term and affect this specific apartment, which would seem to be what you would need to show a high probability that this plaintiff would be injured.
With the exception of the fact that this particular apartment sat vacant for years because it was so badly damaged from 2017's Hurricane Irma.
Let me ask you this, but you'd have to know that there was a high probability that it was going to affect this plaintiff during their lease term, right? And there hadn't been a big flood like this for decades before that affected this apartment. How would they know, or what evidence is there that they knew that there was going to be a flood while this plaintiff lived in the apartment?
This is not the traditional type of community where you think of it as a year-to-year lease, and certainly that's not how the appellants thought of it, or many of the seniors that move into this community thought of that community. They thought about moving into this place as their forever home.
So they should have assumed that they were going outside the lease term and that they would be here however long it took for a flood to come?
This is a retirement community. They are marketing themselves as this is the place where you can grow old and live out the rest of your days.
Right, so assume you have a 100-year floodplain. If we applied your standard to get the punitive damages, anytime there's 2 floods within a short period of time, so somebody knows, hey, you really are in that 100-year floodplain, and you recognize it and try to fix what you can, you can still be punished for it.
But the issue isn't that they didn't fix the problem. The issue is that they knew that this area of the residential community was prone to flooding, and they didn't do anything, not that they didn't do anything about it, but that they chose to renovate and move people in anyway without any kind of warning whatsoever.
Because sometimes in the next 100 years, this could happen again.
Back in the whole thing, though, it was, forget the 2 named hurricane. Irma was the first one or the second one?
Irma was 2017, and this is 2022.
So any apartment that is flooded by Hurricane Irma obviously could be flooded by hurricane, we know. Any apartment in the state that was flooded by Irma, we know that the period could be flooded. Does just every apartment owner then, forever and always, presuming they haven't spent tens of millions of dollars or whatever it takes to change the flood situation, is it just automatic punitive damage conduct? Anytime an apartment, a landlord rents an apartment to somebody without putting a flood warning sign on it? Because I'm not saying why this apartment would be different to many of the other thousands of apartments that were flooded by Irma.
I think that this is, well, first of all, let me just say this is one of a bunch of related cases that we have filed against the police. But this is a unique situation too, and I understand I'm going below the 5 minutes now, but it's important to really make this point. Since then, right, there's been changes in the law to require some flood disclosures on behalf of apartment complexes, in large part to situations like this that have happened across Florida where people have lost everything.
That's fine, but for every one of the thousands of apartments that was flooded by Hurricane Irma, I don't see
Flooded again by Ian, right? I'm not seeing any reason why this wouldn't apply to every single apartment in the state that fell into those two hurricanes.
And counsel, in fairness, I think your brief talks about a water treatment plant, correct? And so maybe there is a slight factual distinction here.
Yeah, it's not just the flooding. It's also that there was a failed sewage treatment plant on the property that contributed to massive amount of raw sewage into the flood that contributed to the losses that did take place. So you're right, Your Honor, that is certainly part of the fact pattern here that we haven't addressed yet. My point in bringing up, though, that there is now the fact that there is a flood disclosure, first of all, with regard to Hurricane Irma, I don't think that there's any chance that there's going to be a bunch of lawsuits coming out, because I think we're past the statute of limitations for the most part for Hurricane Irma. And we're actually speeding up on Hurricane Ian as well, I believe.
Right, but this could be repeated dozens of times into the future when there's two hurricanes close.
Also, Ian is the relevant period, right? Ian is
Ian
when the
right.
cause would occur, right?
Correct, but I think this is a very unique factual circumstance, and I would argue to the court that this is unlikely to be any kind of, cause any kind of mass flood of new litigation, because number one, we are many years from Ian at this point. The idea that people would be filing suits at this point is probably pretty unlikely. And let me just say that people do not bring these suits typically. The reason why there's not a lot of case law that's anywhere near this here is because but for legal aid stepping in and representing these people, no one would have taken these cases. We're talking about $20,000, $30,000 in damages to litigate for years. So if it's okay with the court, I'm going to reserve the rest of my time, and I'll talk to you guys in a minute.
Thank you.
May it please the court, I'm Marie Borland from the Hill Ward Henderson Law Firm in Tampa, and we represent the appellees, Sanford Health and Good Samaritan Society. As the court has recognized, the trial court applied the correct standard and correctly determined that the plaintiff did not present a reasonable basis in the evidence to support an award for punitive damages. And as this court is well aware, punitive damages are the exception, not the rule. There's an extraordinarily high bar for asserting a claim for punitive damages, even more so when it's against a corporation, which is the case in this case. So there were really three categories of evidence that the plaintiff proffered, and I think one of them has conceded today is not
So
really...
before we get to the plaintiff's proffer, can we ask about your client's proffer, the counter proffer? The thrust of your brief seems to be that the non-moving party can essentially put any evidence in the record by filing it. You basically say, we filed this, therefore it was on the record.
Well-
Is something just in the court file, does that mean it's in the record and can be used as
Well-
evidence at a punitive damages amendment?
So what we were saying is under the statute, it just says that the court can consider evidence proffered by the claimant or evidence in the record. So our position is we simply filed evidence in the record.
I know, but what does it mean does anything you file become evidence in the record?
If it's competent evidence, I believe it's evidence in the record that the court can consider. I will say also, Your Honor, that you recognize that there's really nothing in the record that establishes that the trial court even considered our evidence that we put into the record. And I think there were maybe 10
Are you telling us we should assume the trial court wasn't supposed to consider your
No,
evidence?
I'm not saying
All
that
right,
at
well,
all.
then
But I'm
you
saying
need to defend the proffer then.
No. I'm neither defending nor supporting the proffer. I'm just saying that, yes, I believe that
You're not defending your proffer?
No, I'm saying, first of all, it wasn't a proffer. It was filing evidence into the record.
Yeah, okay.
I'm just saying that under the statute, we were permitted to do that. But in terms of reversal, what did the court consider? I'm saying we sort of view it as a non-issue, because really the question before the court is, what did the plaintiff present? And what the court found was what the plaintiff presented was not sufficient to satisfy the very high bar of
So you get,
punitive damages.
to evidence in the record, you got two pieces. You got evidence and you got in the record. So I think evidence needs to be some type of competent evidence, right? Like
Correct.
just the document unauthenticated Just because it's in a court file, does that make it competent evidence?
Well, I don't think that there was ever any argument as to whether what we filed rose to the level of competent evidence or not. We would certainly submit that it does, but
I'm just asking you, does a document, permit application, whatever, unauthenticated, just filed in the court file, is that evidence?
we believe it's evidence, yes.
Why?
Again, Your Honor, I think if there's an argument in the trial court that your evidence that you've just filed isn't competent, then
But
that...
how is that authenticated in any manner? I get your point about what they argue, but I'm asking you about the substance of the issue. Does just any document, without any authentication, become evidence in the record that can be used by filing it?
So, Your Honor, I don't know that I can answer that question in a vacuum because I'm trying to stay within the confines of this case, and in the record in this case, there was never an argument made before the trial court that anything that we filed wasn't competent evidence. The issue was, were we allowed to file it at all?
But
So
on the flip side, was there any finding that it was competent, that each of these pieces should be admitted into the record?
I don't think it was challenged, Your Honor. I don't think it was
Counsel, what they
challenged on
did
that
was call it
basis.
a proffer, and by calling it a proffer, you could argue that means they're saying it's not evidence because it's a proffer, which is by
Correct.
definition not evidence. So I'm not sure I agree with you that there was no argument that this wasn't competent evidence, because that's kind of what it means to call it a proffer. A proffer is by definition not evidence. So I've asked you a few times about the substance, and you keep trying to avoid the substance of the issue. I want you to not do that.
Well, Your Honor, I guess I'm not trying to do that, and I apologize. I'm trying to understand Your Honor's question. So,
Okay, so here's the question. Evidence in the record. Okay?
Correct.
Assume they made all the proper arguments about whether you could submit it. Okay? A document that no one has authenticated. It's not attached to an affidavit. It's not an exhibit to a deposition. Is it proper for someone to file that and say it's evidence in the record? And if so, how, given that it's not authenticated by anyone and there's no proceeding in the case by which it was entered into any record?
well, I think the way that it would work is the evidence would be filed as it was in this case, and then there would be a hearing on the evidence, and there would be discussions, and there would be challenges. And in this case, the plaintiff agreed that it was proper for the court to consider both sides' evidentiary showings. The plaintiff also agreed that certain of those categories were acceptable and permissible.
Hold on, the plaintiff agreed that it was proper to consider evidence in the record, but said that some of your items were proffers rather than evidence. That's what they argued. They said this was an improper proffer, right? That means it's not evidence. And so some of these items didn't go through that process. There was nothing in the case where they were admitted as evidence or deemed to be competent evidence, right? They weren't attached to a deposition. They weren't attached to an affidavit. So as to those items, how do they get to be competent evidence with no authentication? And what would it mean for them to be in the record if that's not, unless you're saying that's just synonymous within the court file?
Well, we took the position, according to the law, that a proffer is a representation of what evidence will show. So the claimant makes the proffer, as the plaintiff did in this case, attached all kinds of things and said the evidence will show this. That was a proffer.
And they get to do that. You don't get the
Correct,
proffer,
correct.
right? You said
We filed, so if we can look at what it is that we filed depositions. Two of the depositions the plaintiff had no objection to. We filed an affidavit. We filed some building permits.
Well, that's a good thing. So a building permit, okay?
So,
How does a building permit get to become evidence without any authentication?
Your Honor, again, I don't think this was challenged in the trial court.
Okay, I'm telling you I think it was, so I want you to answer my question.
Okay, well then, Your Honor, then believe that it was, I don't believe that evidence was not competent, but for the sake of this argument, I would say it would be harmless error.
What makes it competent?
I don't know what makes it competent. It makes it competent that it was never litigated that it wasn't competent. It was evidence. It was.
What makes it evidence?
Well,
And
I think the
counsel-
plaintiff has relied on the same types of evidence. These are, in fact,
They
I think.
get to proffer.
Well,
You don't
but
get to
they
proffer.
actually relied on the actual applications that we filed with the government entities. That was the bulk of this evidence, was the applications we filed with government entities saying, we're trying to mitigate this problem, this is what it's going to cost, we're advocating for funding, we're trying to remediate the property. These were the types of items of evidence that we filed. No one challenged them as incompetent evidence or unauthenticated.
So counsel, remind us, by what method were these exhibits filed, or you were attempting to put them into evidence?
I wasn't the one who filed them, but I
Your
think they were
client.
filed with a notice of filing, and they were
Right, so this was not
attached.
like a summary judgment motion where you attach affidavits, depositions, you're seeking to put them in the record. Someone then responds, has a chance to put forth their contrary affidavits, depositions. That seems to be kind of in the world of, maybe you don't need the judge to authenticate because the parties are right there disputing it. But here it's just a motion to have the judge consider something in a it's not in the proffer world. It's just I'm having trouble seeing how that's getting into the record.
So, Your Honor, again, the case law is that on a punitive damages proposed amendment, the courts can consider both sides' evidentiary showings. A notice of filing was made attaching all of this material.
You keep begging the question. We get it. The court can consider evidence in the record. Nobody is disputing that. The question that we're asking you to answer is, how did this become evidence in the record? And your answer seems to be, well, we filed it. That would mean that just anything anybody puts in the court file is evidence in the record, and I'm questioning whether that's correct, because
Well-
evidence would seem to me to require some type of competence, and in the record to me would seem to require something that put it in the record of this case, as opposed to just the court file.
So I guess, Your Honor, I don't know how else to answer this question other than a notice of filing was made, as it would be on summary judgment. If the parties want to challenge those filings, then it is up to the opposing party to say that the evidence is incompetent. It's up to court then to conduct a hearing and determine whether this is competent evidence.
Counsel, what do you call?
A notice of filing is not a motion. You're not actually seeking to do anything. You're just apprising the court that something exists, correct?
Correct.
People
So,
make notices of filing all the time of things that are irrelevant, extraneous, never considered, that the court's not being asked to do anything with.
right. So, Your Honor, I've answered it the best way I can, and I guess what I'm struggling with, I'm not trying to avoid the question, I'm not trying to be difficult, I'm just trying to say that I'm here to argue that the trial court should be affirmed for correctly denying the punitive damages amendment, because the plaintiff is the one that had the burden of making a showing, an evidentiary showing supporting a punitive damages amendment. So I'm not going to say one way or the other whether our filing was or was not competent evidence. I would say this court can decide this particular case without what we filed. As Judge Mize, you've recognized, there's nothing in the record to suggest that the trial court even considered the defendant's filing. So I could concede, well, let's pretend that it wasn't competent evidence and let's just put it aside. Let's put aside the defendant's filing. I'm going to concede that for the sake of argument, because what I would like to tell the court is what I think the court has already acknowledged, that the plaintiff's evidence fell into three categories, and one has been conceded today is not even a category anymore, and that was the Kaz Fleming statements that I don't think the property will flood again, and the things that they say he said. He says he didn't say them, but viewing the evidence in the light most favorable to the plaintiff, assuming he said those things, as the court has recognized, there was no managing agent from the corporate entities that participated in that. So the Kaz Fleming statements are off the book. I mean, they don't support the punitive damages amendment. There was another category that we didn't get into today, but one of the third category was we were somehow duped into signing this termination agreement. I don't know that it's proper for me even to comment on that because it didn't come up in the opening argument, but the plaintiff's own testimony refutes that. They said they voluntarily signed this agreement. So it really comes down to this notion that somehow we had we failed to reasonably maintain the property in a way that would prevent it from flooding in this, 1 in 200 year catastrophic storm. And I think the court has also recognized that, are we to be penalized for all of the efforts we took to mitigate the property? What could we have done? How could we have predicted this storm? How could we have predicted what it would do to these particular plaintiffs? It's just this category is the sort of the standalone category left, I suppose, and it doesn't come anywhere near to satisfying the very heavy burden under the punitive damages statute. I mean,
And counsel, could you maybe speak briefly about, I guess maybe what would be considered potential omissions that your client made in its applications for, basically getting assistance for remediating or fixing the property up, whether and how you would look at those in light of the intentional misconduct or gross negligence standards?
Right. So in advocating for funding, obviously our client acknowledged the potential for harm from flooding. It had flooded before. And think about it, this was certainly to protect the residents, but it was to protect our client's own property. So they had every incentive to make sure that this property was safe, that it was safe from flooding to the extent it could possibly be safe from flooding. And so in those applications, that's what they were trying to do. I mean, this was going to cost in the hundreds of millions of dollars, but it was going to be an exorbitant cost. They advocated, they told the government entities that, we're concerned about this. The government entities did not find it a high enough priority. The funding didn't come through. So I think the plaintiff has even admitted to even come anywhere close to mitigating against these effects, which, again, I don't think you can do in a storm the size of Ian, that it would have been cost prohibitive. And Your Honor, Judge Pratt, you mentioned the wastewater plant. That is something that we were able to start working on, and unfortunately Ian came through when we were in the middle of the engineering phase of correcting some of the problems with the wastewater plant. So in terms of did we maintain the property in a reasonably safe condition, I would just say, what more could we have done than we tried to do? And even in that case, and beyond that, under the statute, it wouldn't be intentional misconduct, because I don't think anybody could claim that we intentionally exposed our own property in a way that would destroy it and also would cause the residents to lose their belongings. I think it could only, I suppose, come under gross negligence. And it would be the defendant's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed. Well, what conduct? What conduct are they talking about? Our failure to undertake these multi-million dollar...
I think they were talking about your failure to warn, or the alleged failure to warn. Hey, you should have told us.
Well, no, I don't think so, because at the trial court level, the judge asked the plaintiffs, is there a duty to warn of a potential hurricane or flooding? And they conceded that no, there's no duty to warn, there's only a duty to maintain the property.
I think what they said was that no court has yet recognized the duty to warn.
Right.
You can't find a case. I don't think they said there wasn't one. They said that there's no court case saying there's a duty to warn for hurricanes or potential flooding.
Well, and I think that comes back to the Cass Fleming statements. I mean, our clients had, the corporate entities had these employees that met with the different residents, and one employee supposedly said that it wasn't a big deal. But again, this isn't a situation where a managing agent was involved in any of this. So based on the record, I think this comes down to the failure to maintain. I think the duty to warn was sort of, it seemed to me it was a bit conceded. But I don't know what conduct would rise to the level of criminal manslaughter that our client would have engaged in, intentionally, exposing people's, life and safety. I mean.
And counsel, are you aware of any Florida appellate court decisions or Florida Supreme Court decisions with any analogous set of facts or where there has been some finding of intentional misconduct or gross negligence for a failure to maintain a property like this?
Your Honor, I've not seen one, and Lord knows I have looked. I mean, I've done a lot of research trying to find anything, not only in Florida, but around the country, because this just seems like such a, it would be very dangerous precedent to expose a property owner to liability, much less punitive damages, for failing to be able to predict a storm of the magnitude of the size of Ian, the flooding that occurred. I mean, this was a devastating storm, as this panel is well aware. We all lived through it. And it just, again, these facts just don't fit within the four corners of the punitive damages statute. They don't fit within the four corners of Florida law. Again, this court knows, the Florida Supreme Court has said gross negligence has to be akin to criminal manslaughter. This court and Mercer and recently in the Turo decision have talked about the egregious level of the conduct. This was a very unfortunate event. It was unfortunate for the plaintiffs. It was unfortunate for our clients. But there was no criminal negligence involved here. And I would just mention this court's recent ruling in Turo gave example of cases where people died and there was knowledge of the problem that led to these deaths. And this court said even that does not rise to the level of punitive damages. So I would say we are well below what this court talked about in Turo. And again, we don't believe that the plaintiff failed to satisfy their burden under the statute. That's what the trial court said. And we're respectfully requesting the court affirm. Unless the court has any further questions, I'll end.
Thank you, Counsel.
To briefly just address the Turo decision, the facts here have nothing analogous with that decision whatsoever. In that case, it was a third-party platform, and there were individual owners of cars that were renting them out to individuals. Here, we're talking about the actions of the appellees that, in some cases, inactions regarding their failure to warn. It's
Would
correct.
that be
there-
similar in Turo in that they were trying to hold them to a standard where they had to warn the people that there was a light on the dashboard and that could amount to something additional that could cause danger?
The difference here, Your Honor, is that in this particular situation, we know that the direct appellees knew of the risk because of the grant applications. They knew that it was at risk of imminent reoccurrence of flooding at any time. So this is a completely separate issue because in Turo, the notice issue was the issue, whether or not there was notice. But in this situation, we know there was notice.
So would you say that the remedy here was for the landlord to just leave the property vacant until whatever point in the future they felt there wasn't going to be another storm that could damage this property?
That could have been an option until
Complete
then.
economic waste. Just, it's ruined. You built this on a 100-year floodplain. We're sorry that you did that. And now, as a society, we've got to stop building anything on a 100-year floodplain, or you could be subject to punitive damages.
Or they could have paid for the mitigation efforts themselves. We're talking about billions of dollars in this corporation. They could have made that decision. Just because they didn't get the grants that they wanted to doesn't mean that they still don't have a duty to either fix the property or warn the individuals. And even though there was not a statutory requirement to warn at the time of 2022, under just general negligence law, if there is a problem with your property, you have to warn people. And they didn't do that.
What about their efforts on the wastewater plant? Does that not
They-
count for anything?
That was similarly, they applied for a grant, they got some money for that, and we're starting to undertake that. But ultimately, it didn't happen within the 5 years in between the storms. And ultimately, this flooding would have happened one way or the other. And I will just say real quick, there's plenty of examples in the reply brief. The error here was invited by opposing counsel, and it fundamentally changed things. Thank you for your time, Your Honors.
All right. Like I said, we're a law day, so we'll have some questions from our audience here. You're welcome to ask the lawyers anything you'd like about their career or the case. I'll just ask the lawyers, if you do give any answers in response to the case, don't say anything outside the record. You can ask us any questions you like, just not about the case. Any takers? You, sir.
Mr. Anderson, just a question for you all on process and procedure for where you sit today. What do you all do to prepare for these oral arguments? Like, what's that process like?
It involves reading everything you could possibly read about the case. I mean, the briefs, our internal memorandum. Yeah, we all have our own systems. I'm electronic, but I have. It's very smart to, wherever you're going, make sure everything is loaded locally on your computer, because you will get to a new place and the Wi-Fi won't be good. So, yeah.
I'm old school, so I still do
Yeah.
book.
I prefer paper. I do better with paper, but it's just it would be mountains and mountains and mountains of paper. I mean, we have cases with 40,000 page records. Yeah, for me it involves reading every aspect of the law and the facts, and making my own internal thoughts about the case and things that I want to understand better. An enormous amount of preparation goes into any oral argument.
We'll say each panel is a little different. Some panels you might talk extensively about the matter beforehand, some not so much at all, some not till you get here or whatever. So there is some opportunity, but we do always, no matter how we may come into things, looking at it, there's always leaving that door open for the reason we have oral arguments, is to let the parties enlighten us on their view of the case. Even though we already have the briefs and we know what they're focusing on, they can argue it a little bit more precise in the oral arguments.
Judges have different views on oral arguments. I know there's judges that don't find oral arguments extremely helpful. I'm an auditory learner, so I actually really, really appreciate oral argument. And I've had my mind changed to oral argument in multiple cases that I can think of. Any other questions?
Good morning, Your Honor. I believe this question for the general court, but how did you know you wanted to get into a court both for counsel and
Let's look at the lawyers. Take a shot.
For me, it was sort of serendipitous. I started out as a corporate lawyer for about a year, and I was sitting next to a lawyer that was trying to help police, and at the time I was at a small law firm, and he just started asking me to write for police and be a corporate lawyer, and I learned that I really liked it. And I became a appellate lawyer probably within a couple of years, and became board certified appellate now for over 20 years, and it's been my whole career. So it was very serendipitous, but something that I'm really grateful that I went into. That's the first of all.
And for me, I'm the director of litigation at Community Legal Services, so doing appellate is just going to be part of my job sometimes, but this is my personal argument.
And I was a trial judge, and I decided I'd rather do the overturning rather than be overturned. Any other questions?
morning, Rebecca Bear, from New Hampshire Law Firm. My question is, what do you report in attorneys in their oral arguments and responses? And then to the attorneys, how do you prepare for your oral?
Yeah, so I think every judge is a little different. I appreciate, obviously, people who are prepared, who are thoughtful, respectful of counsel and the judges and one another. But also, I just appreciate the conversation. You know, obviously, like when I was in practice and I was up arguing, I have my roadmap and the things I want to get out that I think are important about my case that I want the judges to understand. But I also understand they have questions. And so this is really the one time that lawyers have a chance in real time to actually talk with a panel and try to persuade them. A lot of it's already baked in with the briefing. You can't raise really new arguments at oral argument. But you can try to persuade and help judges see the case the way you do and raise out salient facts that maybe in the brief on the cold record might not read the same way that you explain it to them there. So I just find that helpful.
If I'm a lawyer at oral argument, I want a hot bench because, you know, whatever roadmap you have going into it, you don't know how the judge is viewing the case. And oral argument is your chance to, you know, find out what the judge is thinking and try to address it while you still have a chance to influence it before they rule. So the best advice I would give lawyers going into oral argument is have your roadmap, because you never know, you might get there and the judges might not say anything. But the second they start asking questions, focus entirely on the questions because they're telling you what they want to know. That is the most important thing you can focus on is what they need to address to potentially rule in your favor.
And again, depending on the panel, for those of us as judges, if we're on cases with certain judges, we know it's going to be a hot panel.
I don't know who you're talking about.
I don't know, I have no idea what you're talking about. But yeah, we usually come with our list of questions or issues that we have that if the attorneys don't get to pretty quickly, then we're going to try to direct them to the things that are important to us.
I think there was a lawyer aspect to that question.
For me, I don't release or we don't release it. We can make sure I'm familiar with the entire record, and then I also prepare a original and outline if Dr. Vincent and any questions are asked. I prefer a hot one as well. Sometimes questions are not anticipated and perhaps they're not answered, in the way that you would expect or assume. But again, you can't always predict everything, but I think the best part of what I like is really having the dialogue and try to answer those questions as best as possible.
For me, it was watching a lot of oral arguments, including oral arguments with this panel, as well as doing really court, mock competitions with all these people.
Who played me?
I will say one additional thing to keep in mind for those of you that are aspiring someday to be here. I always like to see when people try to get baited, and Judge Mize's master is great at doing it to try to pull them in. Not arguing. I mean, it's an oral argument, but don't argue. Make your point and move on, and try to get back. And I know we're not going to talk about the case, but like Ms. Borland, you saw how there was a certain point she said, I got to get to these things, and this is what I I think, and that's what you have to kind of do is, you're there to make your points, even though we will be trying to move you in a direction or finding out what we're doing, get back to your script and try to argue for what you think the case is about.
Any other questions?
How do you define after all? How important are they in the define after all? You said that you have a research for a case, so I assume that for your office, you will have a kind of like an answer to how to rule the case. So how important for all of them?
I can't speak for everyone. I don't know the exact percentage, but I've definitely changed my mind after all arguments. It's not usually that like some issue I'm looking at I think is fundamentally wrong, but maybe there was some other issue I didn't think about that might, make that issue moot or something. Or maybe there's just something I didn't notice. No matter how hard you read, you have a large record, and there might be something that you just for some reason didn't jump out at you. So I'm an auditory learner, so it really helps me. I know some other judges don't always find it as helpful, and that's not right or wrong. Right? People are just different. But for me, I really listen and use the oral arguments to help me decide the case. All right. Oh, no, go ahead.
Erica, I'm a first-year law student. Your Honors, how would you want counsel to focus on case law rather than just focusing on the facts of the case?
Which one helps you win? There's a famous saying in law, when you got the facts, focus on the facts. When you got the law, focus on the law. I'm kidding. So it just depends.
Yeah,
on
if you have neither pound the table, right?
And then perhaps particularly for our court, but even just in general, I think in law school you're kind of taught to look at cases as just this on high, the law is being given from the judges, and really I would maybe encourage you to think of it more as like evidence of the law. Obviously you have vertical and horizontal stare decisis, so vertically we are bound by the U.S. Supreme Court, Florida Supreme Court, if its holdings apply to the facts of this case. Horizontally, there's maybe some debate amongst appellate courts or even at higher courts of, you give respect, you have stare decisis factors or tests or whatever, but it's not the exact same thing. And so precedents, particularly for the 6th DCA, were a newer court. We did not adopt any precedent from any other court. And so case law, when it's like read to us, unless it's one of our panels having spoken or a higher court, we're not bound to follow what another DCA said or another federal court usually said. So use it as persuasive if it's in your favor, and if it's not, explain why it's not reasonable.
Any other questions? Oh.
Yeah, I think in law school, I found most helpful for me, obviously work hard in all your classes, but do internships or externships, try to get that real world experience early. Doesn't really matter where, it could be in a prosecutor's office, a governor's office, public defender's office, whatever you're passionate about, and have an eye towards how do I keep improving my skills throughout my career. If you're able to clerk for a judge, that's wonderful. I did that, but I had plenty of friends who didn't, and they were very successful in the things they did. There's no one path to finding the best route for you to have a successful career. Just go where you're passionate and where you make enough money to pay your loans, and everything will work out.
Well, think about that last part. So, think about where you're going to work. So, if you want to do appeals versus, say, trial work, the types of client bases you're going to have are very different because, trial attorneys are typically trying to build a client base, and a reputation among, the general public, whoever they want to represent. Whereas, say, appellate attorneys get a lot of their clients from other attorneys. So trial attorneys whose cases either they're defending what happened to below or they're challenging it. And so in terms of how you build a practice, it's going to be very different with trial versus appellate. And so also think about, where am I more likely to get clients? Do I think I'm going to be better at marketing myself to lawyers if you want to be in private practice? Of course, if you want to be in government practice or nonprofit, those are obviously great routes too. But just think how am I going to make a living with this? And that includes your ability to get the types of clients. I would imagine for appellate attorneys, a lot of your work comes from other attorneys in your firm, right? Whereas if you're a trial attorney, your work is typically much less going to come from other attorneys in your firm because they need those clients for themselves. So, any other questions? All right, thank you, everyone. We'll move on to our next case. Thank you to the attorneys for sticking around.
Thank you.
You guys need a break? You can do this.
This is not working? It's a little funky. I'm not sure why. Mine's funky? Okay.
This is the live stream. Trying to get these other ones loaded. Sometimes it cuts out.
Okay. Gotta have the jacket out again. What's that? Gotta get the jacket out again. One last time.
Blink on this one. You can see it.
You need,
Oh, thank you for having us.
pleasure to be here.
Yeah, good to see you.
That's got nice little care. Yeah, absolutely.
Please take your seats. Please be seated. Please take your seats.
All right, we'll ask everyone to please be seated. If you weren't here for the first argument, if you have a cell phone, please turn it on silent mode. All right. Our next case on the docket is 24-2185 Compass Bay Townhome Association Incorporated versus American Builders Insurance Company. Counsel, we normally leave 5 minutes for rebuttal, but we can do more or less if you prefer.
5 minutes is fine, Your Honor.
All right, counsel, proceed when you're ready.
Good morning, Your Honors. May it please the Court. My name is Samuel Alexander, and I represent the appellant in this case, Compass Bay Townhome Association. This court should reverse and remand for two reasons. First, the trial court erred in its interpretation of the townhouse project definition when it improperly struck 2/3 of the definition as immaterial. Second, the
I
trial...
did notice that 63% number, was it 63 or 67?
It was 63, I believe.
It was an interesting way to write it, because I took your point about the language, but I wouldn't normally think of how I wouldn't normally look at it in terms of the percentage of the words that weren't given effect. I mean, I would look at the words and whether you're giving full effect to the text, but that percentage as a device was something I haven't seen before. Is there anything that says something that kind of we look at the percentage of the text that was given effect just in terms of the number of words, or was that just kind of an argument you decided to go with?
It was just I thought it was a persuasive device to demonstrate how much of the provision was struck.
So you don't think there's a certain percentage that makes it material or non-material? You just...
I think what's important is that the portion that was struck, the 63%, contained an entire element of the definition that the parties agreed.
Oh, yeah, no, so the fact that, and I get your argument that a huge chunk of the text was not given meaning. It was just that percentage device. I was wondering if there was anything more particular that came from.
No, it's not actually material. The second reason this court should reverse is that the trial court erred in ruling that the parties' interpretation that they agreed upon was unreasonable as a matter of law. In fact, the parties' agreed interpretation was the only reasonable interpretation. They agreed that the definition had two elements. One, a physical description portion, units with shared walls, and two, an ownership structure portion, which provided with other parts or portions of the development being owned in common by the unit owners. Because the common elements were not owned by the unit owners, the exclusion does not apply, and therefore Security National was required to indemnify. As for the Tipsy-Coachman argument, as an initial matter, we think there's insufficient factual predicate in the record to grant Tipsy-Coachman relief. They never requested summary judgment relief on a duty to defend. The trial court never made any findings on a duty to defend. But it's ultimately immaterial because the Florida Supreme Court in CTC held that the duty to indemnify is not dependent on the duty to defend their independent duties. The duty to indemnify is determined by looking at the underlying facts of the case, and the duty to defend is determined by looking at the allegations. In this case, because there was a duty to indemnify under the underlying facts of the case, regardless of the allegations, Security National had to indemnify, and the exclusion does not apply because the unit owners don't own the common elements, so this court should reverse and remand for further proceedings.
Is a corporation not one way for something to be owned in common? Did you say that's a mechanism for things to be owned in common? Isn't the
No.
whole point of a corporation?
Well, I think that the unit owners don't own, they own shares, or they're members of the corporation, and the corporation owns the assets. I don't think that you can say that the unit owners own the corporation's assets because they're members of the corporation. And I think that's kind of black letter corporate law, whether it's an LLC or a corporation or an association. And I think the legislature recognizes this difference as well. In Chapter 718, you have the condo statutes, which hold that unit owners have a direct, undivided share of the common elements. And in Chapter 720, which Compass Bay is incorporated under, it provides that generally an association is going to own the common areas, although that's not necessarily the case. But there are practical differences between who owns the common areas legally with regard to decision-making, standing to sue for defects, how the common areas are managed. And Security National wrote a very particular, very specific exclusion.
It would seem to me to be a little, if an insurance company wanted to provide an exclusion for townhome communities, it would seem to me to be a little odd to make it turn on how their common elements are owned, right? I can't imagine a way the insurance company would have, it would matter to them which way they were owned in terms of wanting an exclusion. Is the thrust of your argument kind of the underlying assumption that, yeah, they may have intended to exclude this, but they did a bad job drafting and they paid the price?
No. I think that they wrote a very specific exclusion, and why they did that, I agree, it is a very odd thing for them to have done.
I'm not saying that argument's wrong. I mean, sometimes
But-
you draft a contract wrong, sometimes you gotta live with it. But I'm just saying, is that not the underlying thing here, that they probably intended to exclude this, but they didn't do it effectively, and they owe coverage?
I don't think we can make any assumption on what they probably intended. The only thing that we can assume as to intent is what they put in the contract. And what they put in the contract is that coverage is excluded when you have a development with units with shared walls, and other parts and portions of that development are owned in common by the unit owners. And sometimes under Chapter 720, that's going to fall their way. Under Chapter 720, there are the association does not always have to hold title to the common elements. Sometimes the unit owners do. And so sometimes it's going to fall their way and there's going to be coverage. And sometimes it's not going to fall their way, and sometimes it'll fall their way and it'll be excluded, and sometimes it won't fall their way and there will be coverage. What I don't think they can do is write this very specific and very clear exclusion, and then there's a case where it results in them being required to provide coverage, and they say, well, that's not really what we meant. You know, these unit owners essentially own the units in this case. I think the court has to look at it from the perspective of someone reasonable reading this provision, and if you're a developer and you're reading it, or a subcontractor, and you say, okay, am I going to be covered by this insurance policy? And you look at the first element, and you say, okay, units with shared walls. And you look at the second element, and you say, okay, with other parts or portions being owned in common by the unit owners, so let's go to the covenants and declarations and deeds, and let's see who owns the common elements, and it's not the unit owners, and you go, okay, so there's coverage. And this was the understanding of the provision that the parties had before the court kind of sua sponte ruled that 2/3 of the provision was immaterial, or I guess the second element of the provision was immaterial. And in doing that, the trial court violated the canon against surplusage, which provides that courts should strive to give meaning to every word in a provision if possible. And not only did the court's interpretation render the entire second element of the provision surplusage, but it also in effect renders a lot of the other exclusion surplusage as well, because it leaves a very, very broad exclusion which says coverage is excluded for any development with units with shared walls. So then all of a
So
sudden,
there's a question about how the duty to identify versus the duty to defend would have worked out in practice, because I take your point they didn't move for summary judgment on that. I'm not asking about that. I take your point. And, you're right. It was not in their motion for summary judgment. But putting that issue aside, if the insurer would have gotten this, they would have looked at it, and the complaint would have put it squarely within the exclusion, and so they would have denied the defense properly. How would the duty to indemnify ultimately have kicked in, right? If they get a complaint, which they have every right to deny, does the case then just get litigated, and then ultimately if there's some judgment, you have a right to give them notice afterwards when they now don't have a chance to defend it? Because I'm thinking, your client has the rights of the assignee of KB Homes, and so I'm thinking, how would this have actually worked with KB Homes being able to enforce it, since you're enforcing their rights?
yeah.
And would it have been that they could totally properly have no duty to defend, deny defense, and then have no chance to defend because they didn't know they needed to, but then get a judgment at the end and have a duty to indemnify? Like, how would that have worked out mechanically? You could end up actually having liability for indemnity without ever having an not just a duty to defend, but really never having an opportunity to defend.
Well, I think nothing's, they made a decision, presumably not to defend. They could have done their own due diligence and determined whether or not they thought ultimately, under the facts of the case, there was going to be coverage.
As a matter of insurance law, though, how does that work out? I mean, do they have to do that? Are they not entitled to look at the complaint and say whether this is seeking liability for which we are liable?
They're entitled to make,
investigate?
but that is limited to the duty to defend, ultimately.
I guess
Counsel, would it be more, I guess, in a motion to dismiss, failure to state a cause of action, because on the elements it wouldn't satisfy that, or is it properly done under a summary judgment?
Do you mean in the underlying case for a failure to defend, or in a subsequent case for a failure to indemnify?
I guess under either.
Because I think in the initial case, I'm not actually honestly sure about what the facts are, because it wasn't developed in summary judgment of whether defense was requested and whether it was denied and on what basis, or if it had anything to do with this allegation. But in terms of a practical matter, I think what we're left is with the Supreme Court's holding in CTC, which says that the duty to indemnify is separate from the duty to defend. And I think that case is very instructive. In that case, you had a developer who was sued by his neighbors for building on a setback when he claimed that he mistakenly thought he had obtained a variance. And he requested defense and indemnity from his insurance company. The insurance company said no. Under the facts alleged, you engaged in intentional conduct, and so that's not covered. And he said, well, it was a mistake, and ultimately they went on summary judgment. And the First District Court of Appeal reversed. Well, his mistake is something that falls under the policy. If a jury believes that this was a mistake, they could find that there's coverage under the duty to indemnify. And the Florida Supreme Court affirmed that decision and said, yes, same. If this was a mistake, that falls under the policy. And if a jury agrees with his version of events, there could be a duty to indemnify. But notably, they said, we cannot decide the duty to defend. The duty to defend is a separate duty. It's determined by the allegations in the complaint. We don't have the record before us to develop that. So that's an open question, and on remand, that can be determined.
Counsel, I'd like to maybe turn to the text of the townhouse project provision or exclusion. And I guess looking at it, I guess I wonder if there had just been an additional comma in there, would this have kind of mooted out this whole dispute?
That would have made it clear, but I think that the trial court also came with kind of a rule that it seemed like it was maybe just a misunderstanding of how these things worked, and he thought that wherever he said during the hearing, a townhouse project consists of a development with one or more units connected by shared walls with other parts or portions of the development. And he said, That's an independent clause, meaning that's a sentence, so I think that's where the material language ends. So he also believed that, that the material language, I mean, based on that reasoning, the material language of a provision stops wherever the first sentence stops, and then
I have
everything
trouble
after
trying to
that.
figure out what the trial court meant, because it leaves that, the last part of it, with other parts or portions of their own development, just kind of standing alone, and it seems kind of nonsensical. Did you, I read it many, many times in the trial court's ruling, but I was still having trouble figuring out what the trial court thought with other parts or portions of the overall development meant. What was your understanding of what the trial court thought the work that clause was doing?
I honestly don't know. And I think it's clear from the neighboring definitions that the with language connects to the second element, the ownership portion element. So you have a description that's a physical portion description that says that units or housing units with shared walls, and then you have another portion that says with other portions being owned or without co-ownership, or so that the with clause or the without clause in one case is the beginning of a subordinate clause that is the entire second element.
I have a question. You mentioned the canons. I mean, it's hard to say that it's a plain meaning because this is not that clear, but do you think we even get to the canons when you read it that way, that this is, we can just look at this language and know that what the trial judge says can't make sense because none of those things orderly don't leave out substantial portions of that paragraph?
I think if you just apply the rule that you should interpret a contract by its plain language, we win.
Even though it's not really plain, it's plain enough that we don't have
It's
to
plain
get it.
enough, and it's through process of exclusion. But I mean, it helps to have a canon that says, you know, these words in this provision, you should try to make sure that they mean something if possible, and it's very easy to make them mean something. And then the whole text canon helps a lot when it says, why don't we look at the other provisions and see how they're structured, and they're structured in such a way that the only possible conclusion is that this is a two-element provision. I did want to say one more thing about the Coachman argument in terms of the duty to indemnify and the duty to defend. In CTC, the Florida Supreme Court could not have reached the determination that it made, that a jury could find that there was a duty to indemnify, while still ruling that there's a potential that there was no duty to defend based on the allegations, without a finding that the duty to indemnify was not dependent on the duty to defend. And that holding has been held by the Fifth Circuit Court of Appeal in Gilbane, which cited the Texas Supreme Court. And the Texas Supreme Court said very clearly the duty to indemnify is not dependent on the duty to defend. And this relates, I'm going into my rebuttal time, so I'll reserve the rest.
Thank you, Chelsea.
Good morning. Josh Levy on behalf of Security National. As I was preparing for this oral argument, and I was wondering why this court would choose such a dry case about insurance law and contracts, I was speculating that the court might want to witness how an attorney might maintain its credibility defending an order on appeal where the trial court rejected the appellee's arguments. And let me just say this. In this case, the party's interpretation differed from the trial court's interpretation. But this departure is not grounds for reversal for three reasons. First and foremost, no one disputes that this is a development of two or more individual housing units connected to one another by one or more walls with other parts or portions of the overall development. So what was constructed and what the insured's liability arose out of were its construction operations.
Hold on, when you say nobody disputes that, to what extent are they not disputing that with other parts or portions of the overall development? Because under the trial court's interpretation, I'm not even sure what that part means. So when you say nobody disputes that that whole part applies, including the with other parts or portions of the overall development, what is it everybody agrees to as to the with other parts or portions of the overall development?
To be fair, we did not advance this interpretation.
All right, but you just told me you're going to defend it with
No.
credibility. You specified.
I believe it's textually permissible because what the trial court was doing was it was saying that it didn't create surplusage. It just interpreted the word including as including but not limited to. And so the notion that it somehow deleted the second part of the exclusion is not fair.
All right, counsel, I asked you a specific question, though. So you told me everybody agrees that this meets the language of the provision up to the word including. Okay? You read the whole part up to the word including, and you said everybody agrees that that is satisfied. And what I'm asking is, that includes the with other parts or portions of your overall development. Without the parts after the word including, I cannot tell what with other parts or portions of the overall development means. So when you say that everybody agrees that was satisfied, what is it everybody agreed was satisfied as to that provision? What does it mean? What does the with other parts or portions of the overall development mean that everybody agrees to, as you said?
The court was simply giving examples of what other portions are. I think that my friend agrees that there are other parts or portions of the development, including common areas, buildings, land use.
Yeah, no, I get it. So you're saying that the including is examples of the with other portions. Okay. But if you don't connect the with other portions to being owned in common, then I don't understand what meaning with other portions or portions of their overall development could have.
And maybe and I know it's always not favored as a litigant when judges ask two line of questions at the same time, but if the period basically that the trial court seemed to use goes right before the word including, why does that not render the second part of that first sentence a sentence fragment or an incomplete sentence? Because as Judge Mize is alluding to, it almost begs the question, what is with other parts or portions of the development, overall development, now connected to? What is it referring to? It doesn't seem to just refer to that first part of the sentence.
It's referring to building structures, land, and other examples. It's a the court, I believe, said that this is a non-exhaustive list.
No, I get that. I get that. But like, even if you said with other parts or portions of the development, including building structures or land, what would that even mean? Without adding on at the end being owned in common, even including those examples, the phrase has no meaning.
I believe the trial court applied the canon, the presumption of non-exclusive inclusion.
Counsel, I've asked you 4 times for the meaning of this phrase, and I've yet to get a meaning out of you. What is the meaning of that phrase?
Again, Your Honor, all I can tell you is that it's...
Is the answer that you can't think of a meaning? If that's fine, just tell me the answer and I'll move on, but I'm not going to move on until I get an answer. If the answer is I don't know, I can't discern a meaning under the trial court's ruling, that's fine. But if there's a meaning, I want it. If you can't give me one, I'm going to assume that you agree there's no meaning to that clause under the trial court's interpretation.
I'm just going to go back to what I believe the trial court was doing, which was it was simply just, it didn't leave that clause hanging out there, okay? I think that, what we're assuming is that, after the townhouses, which is the first clause, it was simply just giving examples of the other parts and portions of the development.
But then that leaves out the being owned in common by all other owners of the separate individual housing units. One way or the other, it's leaving out something that appears to be pertinent.
I think that assumes that the building structures and land are all common elements, and that isn't necessarily so.
So counsel, I know you mentioned the trial court kind of hinged its analysis in large part on the word including being kind of a word of expansion, of examples, and that is typically or often how that word is used. But when we look at the whole provision, why does that interpretation, what is your argument that that should be the primary one here, when, it seems like, as we're saying, it's maybe disconnecting that second part of that first sentence if we do that.
I think the first part, if you look at development of 2 or more individual housing units and it goes on, I think the development of is what's required, right? It's consisting of. Whereas the second clause where it just says including, I don't necessarily think that we can assume that every townhouse project is going to include every structure that's listed here. Could you sway
Well, no, I take it that the including is examples of the with other parts or portions of the overall development. I think that's correct. But even including that as the examples, right? Even say that's a list of examples. it would still be an incomplete clause that doesn't appear to me to have any meaning unless you then connect that to being, and other such common elements, being owned in common. So,
I think-
because your argument in the brief was that was the only reasonable interpretation.
It was.
And I don't fancy myself an Einstein, but I'm having trouble figuring out how that works. And I've asked you 5 times to tell me what it means, and you haven't been able to. Can it really be possible, if I can't figure it out, and you can't figure it out, that it's the only reasonable interpretation?
Well, to be fair, I didn't say that the only reasonable interpretation was the trial court's interpretation.
I thought your brief did say that.
No, actually what I said was that it's textually permissible. It's potentially reasonable.
Okay,
Okay.
do you dispute that if you have multiple reasonable interpretations, we have to construe it in favor of coverage?
I do dispute that because under Florida law, if you're going to apply that rule and it's actually ambiguous, it has to actually be ambiguous. So we have to apply the exclusion. And in this particular case, I don't believe when we apply the exclusion, I guess the rule is an ambiguous provision creates more coverage and restricts coverage at the same time, right? You don't just stop at that rule. And so I mean, I think that our argument is that even if you construe it the way the parties construe it, it's not ambiguous as applied.
And what is the reason for that? Is it because you're saying there are 2 reasonable interpretations, but yours is more reasonable, therefore it's not ambiguous? Because I guess when I traditionally think of ambiguity, I think that there are 2, not just permissible, but reasonable interpretations, and it's not really sure which one is which, therefore we find ambiguity. So I guess what is your position of why ambiguity doesn't apply?
Because if there are 2 reasonable interpretations, when you apply both interpretations, one interpretation has to create coverage and one narrow coverage and one expand coverage.
Where does that, I don't recall that, where does that rule come from?
I believe in Auto Owners versus Anderson.
So something is only ambiguous if it appears to both grant coverage and take it away? That's what ambiguity means?
Yes, and that's what Judge Alvaro held in the Nona Preserve case.
So I ask this,
And which court is that from?
It's a trial court.
Okay.
Yeah.
so let me ask this then, what is it, if ambiguity means when a provision both takes away and excludes coverage, what do you call it just when a provision has 2 reasonable meanings, if not ambiguity?
I think in the statutory context, that's correct. But in the insurance context, still ambiguity, it could have 2 reasonable interpretations and Compass Bay could still be excluded.
I guess I'm having trouble then distinguishing why we wouldn't apply that rule from the statutory context, which is just general principles of how we interpret language, whether it be a contract, an insurance provision, a statute. The same general principles of grammar and syntax and our usual rules of reason would apply. And I would tend to think, unless there's some higher precedent that says we shouldn't, that we would just apply, if there's 2 equally reasonable interpretations, then that means ambiguity.
I fear I'm going to repeat my answer.
Understood. You can.
I mean, we can agree to disagree. So with 2 textually permissible interpretations, the question is, what does the court do with that? If we're going to apply the canons of interpretation, I think we can look at the supremacy of the text. And in Scalia and Garner, what they say is that you can. You can look at the purpose of the contract, right? So the purpose sheds light only on deciding which of the various textually permissible meanings should be adopted. So what is the purpose of a commercial general liability policy? It's to cover the operations of property liability arising out of property damage caused by the insurance operations. So if we're going to focus on the common elements, and this is what the judge below below said, the insurance liability doesn't arise out of ownership of the common element.
Is that going to go to the question I started out with your opposing counsel of his argument, kind of the underlying assumption being, I'm not saying it's right or wrong, but the underlying assumption of their argument is, yeah, they probably intended to exclude this, but they didn't do an effective job of it. The language doesn't exclude it, so we get coverage. And you're basically saying, at least look at the purpose and say there was not supposed to be coverage here, right? Like, they were clearly trying to exclude it, and so we should interpret it in a way that they succeeded in doing so.
If you take the interpretation to the extreme, okay, I think what my colleague is saying is that this only excludes coverage if it's a townhome condominium association. It doesn't exclude coverage if it's a townhome homeowners association. And respectfully, I think that leads to absurd results. It's the same damage. It comes out of the same work. The liability is formed long before any of these associations.
Am I right then? Very basically is they were clearly trying to exclude this, interpret it in a way that affects that intent.
I'm not saying you're wrong. What I'm saying is that it would just be bizarre if they were focusing the exclusion solely on what type of community association it was.
Well, counsel, I guess going back to the supremacy of text principle, so we're supposed to look at the text in its proper context and find its fairest or best reading. And I know you're talking about the intent of the parties in drafting, but the best evidence of intent is the plain language. And regardless what parties intend, people are bound, and legislatures are bound by what they say, and people should be able to rely on a reasonable interpretation of that, from a common listener. Be that as it may, I guess just from an intent side, I'm struggling to see if that was the intent, why not just strike everything from being owned in common thereafter to then effectuate that purpose? Because then you would still have the including, giving an example, but then you're taking out all this talk about commonality of ownership. So what purpose did that have if that was truly the intent?
I think potentially, if it just says a development of individual townhouses with other portions or parts of the development, that potentially could be problematic. Who knows what my colleague would argue is that it doesn't include portions of the property.
One thing I found was interesting, counsel, is that the provision, discusses the idea of a corporate entity in the context of managing the property, but not owning it. And that would seem to me to imply that the text clearly contemplates that there might be an entity, but nonetheless said the common elements must be owned in common. It didn't say owned in common or through an entity, even though an entity is mentioned in the context of managing the common elements. Does that hurt your side of the case? It's not like they didn't think to talk about corporations. They did.
They did.
And you would think there must be some meaning to that distinction.
Well, I think the plain reading of the text is it just doesn't matter if there's an association.
All right. Just a final point about that, if you could. So am I correct that it is your position that the interpretation both sides gave below is a reasonable, permissible interpretation? You don't think it's the best one, but you agree it is a reasonable, permissible interpretation?
I do.
Okay.
Yeah.
So there is, in fact, more than one reasonable interpretation of this provision in your view?
It is. I believe the trial court gave the best interpretation.
Yeah. You think trial courts is better, but you agree that there is more than one reasonable interpretation of this provision?
Correct. And again, and I respect the court, I've only cautioned that you need to apply the exclusion as well in order to determine whether it's ambiguous.
Understood.
And okay. And in this case, when you apply the exclusion to Compass Bay, it is the second clause also excludes coverage. Why is that? It's because Compass Bay in its own pleading says, and you pointed this out before, that the exclusion applies because Compass Bay says that its unit owners collectively own the common elements.
Well, you can tell from my discussion with your opposing counsel, I'm interested in how that would have worked out. But one thing you brought up, which seems to be correct, I read your motion for summary judgment, page for page. It did not move for summary judgment on this basis. And the exact type of questions I was asking, we don't know the answer to because they weren't developed on summary judgment. So we can tipsy coachman when the basis for affirming is supported by the record. And when we're tipsy coaching a summary judgment, if the basis for the tipsy coachman is something that would have had to be included in the motion for summary judgment in order to be a subject of summary judgment by the trial court, doesn't that mean that if it's not in the record, if it wasn't in the motion for summary judgment?
The principle is in the record, because it does say that the duty to defend is broader than the duty to indemnify, and we certainly did advance that the complaint was evidence of lack of duty to indemnify.
But you have to file a motion for summary judgment a certain time before the hearing. I mean, there are timing and requirements you have to do. It's not like you can just go to the hearing and say things, right? And so if we were to tipsy coachman on that basis, when you didn't move for summary judgment on that basis, wouldn't we be bypassing the requirements of the summary judgment rule?
And aren't complaints allegations and not evidence?
I think that if there is no duty to defend, there's no duty to indemnify, right? So here our position is that there wasn't a duty to defend. I think Your Honor asked initially, well, how does that work? So the claim is tendered to the insurance company. The insurance company reads the complaint. The allegations fall squarely within the exclusion. Well, what happens then? Does a settlement occur, and then the claimant or the insured is come back and say, here's a settlement. You need to indemnify. And that's not the law.
But you agree there's nothing in the record about how that would have worked out in this case, right?
It's in our summary judgment motion that the duty to defend is broader than the duty to indemnify.
Can I ask you one question for your time runs out? It does seem like, in terms of the manner of the ownership, and I think the trial court commented on this, that there wasn't a cross motion for summary judgment here, but it doesn't seem like there's any issue of fact here in terms of the ownership. It doesn't seem that anyone disputes that the common elements were owned by the association. You just dispute, assuming their interpretation and your former interpretation applies, you dispute whether that constitutes common ownership by the unit owners under this exclusion. You say that ownership by an association qualifies, and they didn't have to have direct ownership. But it doesn't seem like there's any dispute as a factual matter that the common elements were owned by the association, correct?
We presented evidence that in order to convey the common elements, there needs to be a vote of the members. And so to say that it's not like a normal corporation where the stockholders,
That actually is like a normal corporation. There's lots of corporations that certain transactions have to be approved by the shareholders. That's like a very common thing in corporations, right? They vote on the board meetings. If you want to sell essentially all the assets or certain assets, that actually is like every other corporation, or at least many corporations. That's a very common provision in corporate law to require shareholder approval for certain transactions.
So the shareholders can get in and out of the corporation when they want to. These are members of an association. They have to pay dues. They have to live there. They have to be part of the association. So they do have some interest in how the common areas are, in this case, conveyed.
I guess what I'm saying is the mere fact that the members had to approve sales of certain property doesn't mean they own the property, just like the shareholders of Coca-Cola don't own the bottling plant just because there's some provision that says Coca-Cola can't sell its bottling plants without shareholder approval, right? That doesn't mean the shareholders own the bottling plants, right?
I take your point.
So I guess I'm asking, is there a dispute that the association owned these common elements? Do you think the evidence showed a factual dispute on that?
I do think.
All right, thank you.
Thank you, Your Honors. So I think it's important to note that my friend on the other side has conceded that the parties' agreed interpretation was reasonable. In that case, if there's a reasonable interpretation that excludes coverage and a reasonable interpretation that grants coverage, the court should construe in favor of coverage. We maintain that the parties' agreed interpretation provides coverage because there's no dispute that the unit owners own common elements.
And counsel, I guess regardless of the party's position on that, that's still just a matter of law for us to determine, correct?
Correct. But I think between the whole text canon and analysis of the neighboring definitions, just an application of standard rules of grammar, what does the with connect to? If it connects to the first part, what does that do with the word including? If including is attached to with, then what is being doing standing there? The only way to make sense of it is for with to connect to being just as it does in all of the other provisions.
So does this reading require us to apply a comma that's not there?
No, I don't think so. I think that
And if so, is that a problem?
I think that it would help if there were a comma, I believe, before the word being, but I think that there's no one rule that trumps any of the other rules, and you have to read all of these in conjunction with an application of common sense as a reasonable person.
In other words, just because it could be more clear doesn't mean it's not clear.
Correct. And on the duty to defend versus the duty to indemnify, I just wanted to stress that as like a policy matter, I don't think that a defendant who has an insurance policy their ultimate determination of whether or not they're entitled to coverage under their contract with their insurance company should be dependent on allegations made by a non-party to that contract against that defendant. So I think if we were to take a hypothetical of, let's say, you're a homeowner and you have a homeowner's insurance policy, and the trees in your backyard rots out and falls over and hits your neighbor's roof and crushes their roof, and they sue you, and in their allegation they allege, let's say falsely, that you have a dog, and for some reason your insurance policy says that if you have a dog, there's no coverage for anything that happens on your property. And then you ultimately settle with your neighbor, and then you go to your insurance company and you say, hey, there was negligence, there was an accident, I'd like to be covered under my policy. And they say, well, you have a dog, so you're not covered. And you say, I don't actually have a dog. And they say, well, your neighbor alleged in a previous suit that you had a dog, and so there was no duty to defend, and so there can't ultimately be coverage under the policy. I don't think that a non-party to this contract's allegations on information and belief can ultimately result in whether or not an insurance company is required to provide coverage that should be based on the facts as they are. And I think that's what CTC holds, where it says that the duty to indemnify has to be based on what the actual state of affairs in the real world is, whereas the duty to defend is based on the allegations in the complaint, which makes sense because that's what puts the insurance company on notice of what's potentially at issue in the case. The Gilbane case from the Fifth Circuit Court of Appeals holds the same. D.R. Horton from the Texas Supreme Court holds the same. The WellCare case from the Wisconsin Supreme Court holds the same. Seventh Circuit Court of Appeal, Keystone holds the same. And they mention the kind of note that theories of liability can be shifting throughout the course of litigation. Often people plead intentional conduct. Maybe there's a settlement, it turns out, based on an admission that there was negligent conduct. Just because there was no duty to defend in those cases doesn't mean that there's not ultimately coverage under the policy as there is in this case. So for those reasons, we respectfully request that this court reverse and remand for further proceedings.
Thank you, counsel.
Thank you.
All right, we'll have another question and answer session. If anybody has any questions for these attorneys, or I assume no more questions for us, but if anybody wasn't here before and wants to ask one, we'll take it. Any questions? Back.
Good morning, Your Honor. I just wanted to ask what areas of law do you feel offer the most interesting arguments? And that's going to be a question for the applicant.
I mean, it really just depends on the case. I mean, every area of law can have really interesting things. I would say it's more fact specific. So yeah, I wouldn't say it's like criminal or civil or insurance or anything. But we get some pretty interesting cases. We get some ones that are the opposite of interesting too.
I also think a lot of times it depends on the judge and what they find interesting. So sometimes there's like our case for Thursday has to do with water rights, riparian rights, and something you don't see very often. But that's something that we're all learning about this week or in the months leading up to it. So this case, I think Judge Mines is exactly right. Not a lot of people are like, wow, those insurance cases, when we can get in and really analyze the details of those words, that's not what most people would think are interesting. But I have to know that Judge Mines lives for these things. This is
You know, in talking to the judges, I find that they tend to be interested in the type, most interested at least, in the types of cases that are different than what they practiced. So the judges from a criminal background tend to find the civil cases interesting, and the judges from a civil background tend to find the criminal cases interesting, or, you know, maybe that's just the ones they talk about because they have more questions about, but, you know, I didn't do criminal law as a practitioner, so it's because it's new, I find it interesting in that aspect, but I've been here, you know, a little over 3 years, so maybe that'll, over time, maybe it'll equalize, but right now I find the criminal aspect of it really interesting.
And that was true. When I took the bench on the circuit court, never done any family law or criminal law. And I was in-house counsel, corporate counsel, did mostly civil my whole career. And you get into it, it was new, it was interesting. Then you get up here, the family law cases can get very interesting. Some of the criminal cases, I mean, that was my experience on the felony bench. I was from Polk County. For those of you that know, I'm practicing over there with Grady Judd as our sheriff. There's never any absence of interesting issues that were coming before us in felony court over there. And now we get to see all kinds of interesting cases all the way up to, but excluding capital cases, fortunately, we don't have to deal with those.
And I'd say regardless of the interesting nature of the subject matter, I know for all of the judges I can speak for, we approach each case with the due diligence that it needs. These are obviously very important to the parties and to their attorneys. And so even if it's only particular to them, that might be their whole world. And so we definitely are aware of that.
Other thing, you know, we get an audience sometime for these law days, and you don't always get as much of an audience in trial courts, even though they're open to the public. And if any of you are interested in trial work, or even if you want to be an appellate attorney, you know, it helps to understand trials, obviously. All the trial courts are open to the public, and trial judges are elected officials. They will love an audience. If you call your local trial judge and say, hey, do you have a criminal trial or a civil trial coming up? They will be happy to give you their trial calendar, and some of the trials are just absolutely fascinating. And there's very, very rarely anyone there to watch. It's interesting, like Court TV is very popular. Like everybody has the live show and it's free, and very few people take advantage. Even sometimes the things that are on Court TV, I mean, no one shows up in person.
If you really want it to be interesting, just show up, find out what's going on, but show up unannounced and sit there for, if it's a 3-day trial, sit there for a day. My bailiff would generally try to figure out what are they here for. Are they a friend of the victim? Are they one of the parties, or you know, family member, something like that? And eventually, after a while, he would ask them, "Hey, so well, you're just observing to find out," because there's so few people who actually do that.
Any other questions? Oh, yeah, go ahead.
Your Honors, going into a case, how many days of research or research a month possibly go into it? And then as a panel, do you go over the trial court rulings as a panel, or do it separately and during the actual arguments go over them?
How much preparation time I put in just depends on the case. You know, in every case, you're going to read everything relevant to the case, every brief, our internal memorandums, you know, whatever cases are relevant, you know, the relevant portions of the record. We have cases that have 200-page records, and we have cases that have 400,000-page records. And we have cases that raise one issue and cases that raise 10 or 12 issues. And so there might be a case where you spend, you know, a day preparing for oral argument, and there might be a case where you spend a week and a half. It just completely depends. Sometimes we talk about the cases beforehand, and sometimes we don't talk about them until after. Whether or not we've talked about them before, we will typically talk about them immediately after. So we usually conference, at least oral argument cases, right after the oral argument.
To give you an idea of how the process works, once the briefing starts, you know, it can take 6 months, 8 months for the parties to finish, depending on what continuances or other things happen. And then at that point, it gets assigned to a panel. One of us, as a 3-judge panel, is assigned as primary, and we have clerks that help us write those briefs, those memos up, and the shares of the other panel members. And sometimes they may have questions that'll go back to the law clerk, and we work on it, work through it. But you know, it's typically months ahead of time. We try to let the parties know at least 9 weeks prior, I think is under our rules. You know, we try to do it before that if we can, so they have time to make sure their calendar's cleared. So we have several months in advance of oral arguments to be reading, reviewing, and preparing for the case.
Any other questions?
mean, as between the judges and the attorneys? I think it's the nature of what we're doing here as an appellate panel, because the record's already complete before us, and there would be similar to what you might see in an argument at sidebar or something with the attorneys, where they're arguing an issue before a trial judge. Then you would see maybe some more of this where they'd be presenting case law and argument. But in ordinary cases in a trial, when the judge is sitting as a trier of fact or actually has a jury as a trier of fact, you don't see that as much.
Yeah, and I kind of look at the appellate process as a little bit more active than the trial court, which is tending to be a little bit more passive, because the trial court is a gatekeeper. They're making evidentiary rulings. They're making sure things get to the jury properly. They can use their authority sometimes to ask witnesses questions, but when I was an administrative law judge, I kind of usually would sit back and I would let the parties present their case. But on appeal, it's a little bit inverted, because they're now presenting arguments to us, and it's our opportunity to interact with them in a polite way, obviously, but to try to get the law right. Judges want to get the law right for no matter what level of case they're at, but there is a little bit of an extra burden for us, because we realize, when we make pronouncements and an opinion, that decision is binding on trial courts below us. Parties will take notice and follow it, and so it's helpful for us to tease out the nuances in a way that trial courts often just don't even have the time to do. They're just doing the best they can with limited resources, and they do an excellent job. They don't have the luxury of the law clerks and the time to reflect and really think through some things we do, but they obviously do great work.
Any other questions?
I just follow on what Judge Pratt just said. As far as the difference in the timing, I just talked about how many months we have in advance to look at, like this case where we're looking at language, or other cases where we're doing it. Trial judges are having to make this determination. They may have a docket with 12 or 14 cases that day. They may have some hour-long hearings to have no idea how long the hearing that this decision was made in was, but they just have to keep going rapid fire, because that's how the process keeps things moving. These attorneys are asking for time on a judge's docket for 15 minutes if they think it's a 15-minute hearing, for an hour, or maybe a half day. But those decisions have to be made. The judge has a little bit of time from the time they get the documents to review them and make a decision, and then it moves on to us. So while it might be easy to say, wow, why would a judge have done this or done that, for those of us that have been on the trial bench, we understand that it's kind of rapid fire a lot of times, and you have to move on, and you're going to get some right. As the judge might have said earlier, it's better to be up here being the one reversing than being the one being reversed.
Being a trial judge is a more difficult job, in my opinion. Both very important, just in terms of because you make these decisions in a very rapid scenario, often with less resources and a lot more of them. So I have a lot of respect for trial judges. Any other questions?
Hi, Your Honor. My name is Mark. I'm a lawyer. I was just curious on how often do you see the same appellate attorneys present for you, and if that has any effect on questions.
Yeah, I guess it depends on what kind of a job they've done in the past. You may come with a preconceived notion about them or not, but we do see the same people in some cases over and over again, and then we often get to see new faces.
Yeah, it's always, like I said, I really use the oral arguments. Like, I find them very helpful. I'm using them to decide the case. And so, if you know an attorney is capable, that's helpful, because you're like, all right, I'm going to get some useful information here that's going to help me decide the case. So, to the extent someone is good at their job, it's always good to have good attorneys. That's my only thought.
And the attorneys have the case that was presented to them to come up and argue, so you have to do the best job they can with what they have.
Any other questions? All right, attorneys, thank you for sticking around.
Thank you.
We're adjourned.